Bars and drinking, they go together, don't they? Isn't that the reason bars exist? And wouldn't you think that if a bar served so much alcohol to one of the patrons and they got blotto drunk and hurt somebody else, the bar would be at fault? Not necessarily so. And that brings us to this week's case. It's a case that arose in Washington, the state of Washington. And there was a guy, believe it or not, his name was actually Hawkeye Kincaid. Now, Hawkeye was in a bar outside of Bellingham, Washington. Bar was the Moose Lodge. His girlfriend was a bartender there. Well, Hawkeye was hanging around and he kept buying more and more drinks, and the drinks kept coming his way, kept coming his way, kept coming his way, and he got absolutely blotto drunk. Gets in his car, starts driving down the highway. Not surprisingly, he swerves across the center lane, bam, slams into this woman, Bianca Faust, and her family. Hurts everybody in the car very badly, and particularly Christopher Faust, who was paralyzed for the rest of his life. Unfortunately, Hawkeye died in the accident. Okay. Family has all of these injuries. A little boy, 7 years of age, is going to be paralyzed for the rest of his life. They sue the bar saying, hey, you are at fault. You kept serving this guy so much alcohol that he was clearly drunk, and you still kept serving him alcohol. He got out, got in his car. You're at fault. Well, in the state of Washington, the law is that a bar is not at fault for someone who becomes obviously intoxicated unless they continue to serve the person drinks. So, at trial, the evidence came forward and it was established the guy was clearly very drunk when he got into his car, and the jury found that the bar was at fault. But the bar appealed this. And they said, no, we're not at fault because, and here was their legal argument, we're not at fault because you have to show at point of service that the person was drunk. In short, when he was handed each drink, you had to show that he was drunk at that time. Well, the Washington Supreme Court looked at this case and they said, no, you don't. All you have to do is show that the guy or gal that's getting served alcohol is drunk, and that's all you have to show. And you show that the person who was serving the drinks knew that he was drunk, knew that she was drunk, and continued to serve him drinks, and the bar becomes responsible. And in fact, they reinstated the jury verdict, finding the bar was at fault. Now, is this going to happen in every state? Not necessarily so. And I think there's a general misunderstanding about what happens with regard to the responsibility of bars that serve alcohol. That's called a Dram Shop Act, and in the majority of states, there is a law that says the bar is at fault. But in 17 states of the Union, some of them very large, including California, not surprisingly Nevada, a smaller state, but rumor has it there are places there that serve alcohol. And in these states, in 17 states in the Union, if someone is in a bar, gets absolutely totally drunk, and is over the age of 21, goes out and hurts someone else, the bar is not at fault. And I think that comes as a surprise to many people. Well, we bring you this story, this case today, because this is how the law really works. We want you to understand that, and that's why we come to you every week. My name's David Allen.